Hey, 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 it's your girl, your favorite paralegal, aka Cassandra Lynn, and welcome to Legal Doc Talk 24/7. Hope you guys are having an amazing Saturday. Thank y'all for, staying tuned into the court docket read for Miss Elise Chambers. If you came over from the other video that I did on the True Crime channel, pretty much we went over her charges, we went over the story that was on Law and Crime. Shout out to Law and Crime for that story read. And then we took a look at her Facebook and some of the comments that people posted. If you aren't aware, definitely go back and watch the video on my True Crime channel. But she posted a video, not a video, she posted or made a post on Facebook at 8:30 something in the morning talking about she's pretty much tired of her little boy. And then less than 2 hours later, she was picked up. But baby, when I said that the internet is undefeated, dumb people were tearing her up in those comments. But if you haven't checked that out, definitely go check out that video. But I want to bring to you guys' attention her court docket records. And I did find some interesting things in her case files. So let's tap right on into it. Oh man, the world that we live in, this is the year that people are definitely reaping what they sow. So, what we have on a screen is her case listing, and there are several things on here that are kind of disturbing. The very first thing that I want to point out to y'all is this stalking. The case type was adult abuse stalking. It was initially filed on October 22nd, 2018. Um, Let me go to the docket. So here, an ex parte order of protection was placed um, to get her to stop doing whatever it is that she was that she was doing. She was literally stalking. Here it says the reason for the protection order is that she was stalking. I want to know who she was stalking. All right, then let's see. Coming here, let me see. All right, so on the 22nd of October, uh, they ordered for her not to abuse, stalk, or M word. They ordered her to not enter or stay, and I'm pretty sure near their place of business or residence or anywhere for that matter. They couldn't communicate with the petitioner. Also, they stated that she has to be within 100 feet of the petitioner, or she can't be within 100 feet of the petitioner. Okay. Then, they have their hearing. Which was on the 8th of November, in which the judge issued. So once he appeared, the petitioner appeared, but the respondent failed to appear. And so a full order of protection was granted. It was approved by the judge. And it state once again the things that I've read, they can't abuse, stalk, or M word, they can't communicate. And so this was actually let me see. It said that it expired November 7th, 2019. But this time that she couldn't be 500 within 500 feet of the petitioner. So that's crazy. And this right here says petitioner granted possession of residence. So I'm wondering if it's somebody that I don't know if she lived with them. I don't know. It's not too much on this. I wasn't able to pull any court records, but I just thought this was very, very interesting. So keep this in mind when I read what I'm about to read. I think, is it next? No, not next. Shortly. Let's put it that way. And then we have this case right here. It is a personal injury case. And once again, she did not appear. And so there was a default judgment that was granted against her. She owes about 13,000 on that case. But I do want you guys to pay attention to the latter three. The first one is the charges that were filed on October 9th, 2024. So she was already in trouble when she got in trouble again. The second one is the child abuse or the child neglect. And well, yeah, child abuse and child neglect. Let's put it that way. And then the last one, because of what happened, she's getting kicked out. She's getting evicted. And I'm going to read that to you guys as well. But let's take a dive into this case, y'all. So here were the charges. Y'all gonna be like, what? So there's a total of 4 charges: burglary in the second degree, and then she has 3 counts of stealing. Let me pull this up for y'all, because y'all gonna be like, what in the world? So I'm gonna read y'all the indictment that was filed. Here are the charges, and it reads: Count 1, burglary, second degree, Class D felony. That Elise Chambers, in violation of Section 569.170, committed the Class D felony of burglary in the second degree, punishable upon conviction under Sections 558.011 and 558.002, in that on June 3rd, 2024, between 9 a.m. and 10:30 a.m., in the county of St. Louis, state of Missouri, the defendant knowingly entered unlawfully in a building located, and I redacted that, who in is owned by, and I redacted that person's last name too. We're going to say Latin, last name Midwest, for the purpose of committing stealing therein. All right, that's part 1. Count 2, stealing credit cards. That Elise Chambers, in violation of Section 570.030, committed the Class D felony of stealing, punishable upon conviction under Sections 558.002 and 558.011, in that June 3rd, 2024, between 9 a.m. and 10:36 a.m. at that particular address in the state of Missouri, the defendant appropriated a Midwest Bank Center Visa debit card, which was the property owned by blank, and defendant appropriated such property without the consent of that individual and the purpose to deprive that individual thereof. Now, the person is Midwest, so she stole Mr. Midwest's credit cards. Part 2, or count 3, credit cards again. So between June 3rd, on that pretty much that same day, let's put it that way, okay? She appropriated a Midwest Bank Center Visa card, which was the property of another individual, and defendant appropriated such property without the consent of that lady and with the purpose of depriving that young lady. Or I don't know if she's young or I'm depriving a young lady. I'm just gonna say that. Then the 4th count, this is another individual stealing credit cards again. So that same day, between those same hours, the defendant appropriated a Dell laptop computer, a key fob for a Nissan Rogue, and the blank's Visa debit card, which was the property owned by another individual. And the defendant appropriated such property without the consent of that individual and the purposes to deprive that individual. So this was the true bill that was submitted. She had a bond of $40,000 cash only. Me, and y'all know what cash only, I explained that in the what case was that? The lady who left her kids in that house for about 5 years. So she has to pay $40,000 up front in order to get bonded out. It is no going to the bills bond and paying this percentage. Okay. This lady. So here is the warrant for her arrest. Um, says $40,000 cash bond. I mean cash only, and it says no 10%. I'm not sure exactly what that means. Um, and then it says filed in circuit court under $40,000 cash only, no 10%. Warrant previously issued and the cost shall be. Okay, so this is just recalling the warrant. So going back over to the court docket, let's so I can show y'all this stuff. So on this one, this is where she initially had a hearing. Um, she made her initial appearance. Now here's the so the warrant. So she had a warrant October 9th. The warrant was issued 2024. And let's see, the warrant was finally served when she was in custody. So the date that they she was in custody because of the child abuse, they said gotcha. And she was formally arraigned on the February 19th. And now she has a counsel hearing on or status counsel status hearing on March 13th at 11 a.m. Okay, so that is for that particular case. Now we're going to tap into the child abuse case. So here, her charges are abuse or neglect of a child, serious emotional or physical injury, no actual contact, kidnapping in the first degree, and then another charge for abuse or neglect of a child under section 568.060.5, no actual contact. All right, so those were the charges. Um, Now on this one, oh my gosh. So we're going to tap into her bond and everything, but she had her initial bond reduction hearing on the 26th, and then it was on the 28th, and then based off of so the first time she was like, I need private counsel. So then they rescheduled it to the 28th. Then she said, I still need private counsel, but I need access to the phone. So I think she needs to make phone calls. So somebody, because on your Facebook, you said you was an entrepreneur, a tax, and what was it that she credit specialist. So I'm assuming you got bank based off of what I've seen on Facebook. So either you got the 40K. Well, no, she don't, because if she did, then she wouldn't be asking for a bond reduction. But it is what it is. So she asked for a phone so that way she can also try to see if she can get private counsel. And so they rescheduled it for Monday. So I am going to tap in and see what happens at this bond reduction hearing. But y'all, um, trigger warning. I'm just gonna say trigger warning. Let's get into. I'm gonna read the. Let me read the indictment for that one. Give me a second. I'm sorry. Here's the complaint that was filed. Um, I just really don't understand some people. Like, why have kids if you're going to treat them this way? It's just like the people were in her Facebook comments tearing her up, baby. This here, it says, look at this, $250,000 cash only. Cash only. So not only do you have the $40,000 from the credit card stealing and all that other stealing, you also have $250,000. And you have to pay this much in order to get out of jail. So right now, she is darn near up to $300,000 cash only in order to get out. That's why she is trying to get a bond reduction. All right, so we have all three counts abuse, two counts of abuse, and then I don't know what this kidnapping charge is for, but we're about to find out. Um, oh man. All right, so let's tap into the first part. Like I said, trigger warning, trigger warning. That Elise Chambers, in violation of Section 568.060, committed the Class B felony of abuse or neglect of a child, punishable upon convictions under those sections. In in that on or about February 17, 2025, in the county of St. Louis, state of Missouri, the defendant was 18 years of age or older and knowingly caused PC, a child, less than 18 years of age to suffer physical and emotional injury as a result of abuse by restraining him with zip ties while he was beaten, and the injury inflicted was serious emotional injury on the child. Now we're going to see what the kidnapping part is. Oh, let me see. The defendant unlawfully confined. Oh, okay. Because that makes sense now. So because she confined him without his consent for a substantial period for the purpose of inflicting physical injury on or terrorizing the child. So that makes sense. So she zip tied him for a certain amount of time, causing physical injury or terrorizing. That is considered kidnapping. Mm. And then also, she because she allowed for him to suffer from physical injury, that's also considered a neglect. So those are the charges. Now it makes sense. It makes sense. Ooh, y'all. All right. Here are the let me go ahead and just put the trigger warning because all right, this is the affidavit. I, Richard Kranz, St. Louis County Police Department, and this is his affidavit. Knowing the false statements on this form are punishable by law, state that the facts contained herein are true and documented in report number 25 5586. I have probable cause to believe that on February 17th, okay, um, on February 17th within the St. Louis County, this female and then committed one of more of those criminal offenses. So count one, count two, count three, everything that we just read states the facts supporting this belief are as follows. On February 17, 2025, police were notified of a child abuse incident by a friend of the defendant. This friend reported that she had stayed the night at the defendant's house the night before. The reporting party noticed that victim, a 5-year-old, was singled out for the punishments that the reporting party described as brutal. On multiple occasions, the defendant would have the child ball his fists up and would beat his knuckles with her phone. The defendant had him do wall squats longer than anyone in the military should. The defendant locked the child in a closet and blocked him in with a dresser. Around 3 a.m., the reporting party woke up hearing the child screaming, crying, and begging something to stop, sounding like it was coming from downstairs. The reporting party got up in the morning and noticed that PC was not in the bedroom with his brothers. The defendant says the child is downstairs. The reporting party goes downstairs and finds the baby zip tied with his hands behind his back on the floor with his pants around his ankles. The child was covered in marks and bruises. This was videoed by the reporting party. The other children in the home corroborated that the defendant beats the child with belts, cords, and hangers and makes the child stay in the closet. Victim, the baby, was taken to the hospital and was admitted, in part for malnourishment. Defendant admitted that she uses belts, cords, and zip ties to punish the victim for sneaking food. She also admitted to leaving the baby zip tied for at least 2 to 3 hours. Defendant is the victim's biological mother. I have reason to believe that the defendant is in danger to the crime victim and the community based on the seriousness of the offense as well as previous arrests for unaliving in the first, assault on a law enforcement officer. Whoa! Additionally, she has a pending case in the circuit for burglary in the second degree and 4 counts of stealing and cause number. I believe that the defendant will not appear in court in response to criminal summons and a warrant is requested. Y'all, I glance over these to kind of see if there's anything that I need to crop out, but now I got to tap into previous arrest for unaliving in the first degree and assault on a law enforcement officer. I'm writing that down. I did not see that the first time. Oh man. Wait, what? Oh my gosh, I'm so confused. I mean, I'm not confused, but that really just threw me for a loop. That really threw me for a loop. So in this case, she has a hearing on Monday for bond reduction. All right, now going into the rent and possession. So in this particular case, well, here's the docket entries. So on the February 21st, her landlord decided to file an eviction to obtain possession of the home. And it kind of makes sense because if you think about it, if she's currently incarcerated, how is she going to pay the rent? Okay. And so they lose out on money if they are, not getting paid rent. So they got to clear out the stuff that's in the house and then go ahead and put it back on the market. They got to put it back on the market because they have to, make their money. So here is that. So I don't know. Now it said a John Doe. It said a John Doe. So I don't know if there's somebody else that is in there, a male possibly. Um, so we're just gonna get to it. So y'all know it's an eviction, right? All right, so they created the landlord-tenant relationship between plaintiff and defendants for 2000. So 2100 per month, which is due on the first day of each month. And they had a copy of the lease agreement. All right, so here is now they said defendant John Doe is any unknown adult occupant of the property. So I don't know if they confirmed that, but whew, y'all check this out. On February 20th, 2025, plaintiff, so the homeowner or the property owner was notified by law enforcement that the following unauthorized or illegal activity occurred at the property. Because if you guys are renting, you have to make sure that you read your lease agreements because you cannot have any type of illegal or unauthorized activity going on, or you will be booted out. You will be booted out. On or about February 17th, defendant Elise Chambers' friend notified the police that during her stay at the defendant's house, a child abuse incident occurred where defendant's 5-year-old son was singled out for punishment that was brutal. Defendant allegedly on multiple occasions would have the victim ball his fists up and be so pretty much everything that we just read. So that was sent over to the property owner. Then it states that she has pending charges um, for that particular incident in the circuit court. Um, it says defendant Chambers caused physical injury to other tenants when defendant harmed her 5-year-old son who was residing at the residence. Wait a minute. Defendant Chamber caused physical injury to other tenants when defendant harmed her 5-year-old son who was residing at the residence pursuant. Plaintiff has made reasonable attempt to abate the emergency situation through public law enforcement authorities and or local public human services personnel pursuant to. I'm not because I'm trying to figure out if they're saying that like they knew of the situation and she was causing injury to other tenants because they were trying to take up for the 5-year-old and that the plaintiff tried to do something about it through the law enforcement. This is crazy. All right, so wherefore plaintiff prays for judgment against defendants Elise Chambers and John Doe's for the restitution of the property which forms the basis of this lawsuit for a order restraining and enjoining similar activity on or in the immediate vicinity of the property and for all other further relief that the court deems just and proper under the circumstances. Oh man. So defendant owes $1,803.17 as of February 21st. So she didn't even finish paying her rent. Or is that nah? Where there is more than one defendant are both liable jointly and severally for the amounts due and owing under the residential lease agreement. So as of February 21st, she owes about a good 1800 for that. So it is warranted. It is warranted, but I think that they are at this point, they want them gone. They said, and for judgment against defendants for immediate possession of the demised premises, together with costs herein incurred. So they want their unpaid rent and they want possession of the premises. That's it. That's all. And that's just a verification of the application for eviction. This is beyond wild, y'all. So the only y'all how y'all gonna serve her? Y'all gonna have to serve her through her attorney if she has an attorney, but they're gonna have to serve her in jail. But y'all, I know we just covered a lot of stuff on her. So to wrap this up, she is a stalker. We know that she is a thief. We know that she's a horrible parent, and obviously, she owes rent. And on top of that, she was arrested in regards to I almost said it, an unaliving in the first degree, and attempted or an assault on a law enforcement officer. I have to find that case because I don't know where that case is. I don't know where that case is, and I got to find it because if that's the case, that is wild. That is bananas. And I don't feel bad for her. I really don't feel, I didn't feel bad for her because of what she did to that baby, but I hope that they throw you up under the jail. I don't know what it is about this year. Like I said, it's the year of reaping everything that you have sown. And if you have sown bad things, you are going to be suffering the consequences this year. It will catch up with you. But y'all let me know what y'all think about this in the comments below. Don't forget to like, share, and subscribe. Until then, you all be blessed and I'm out. Bye.